We're all attached to our phones most of the time that we're awake, and it's hard to put them down. That may get a judge in Oklahoma in a little bit of trouble, or not. Welcome back to Sidebar here on Law and Crime. I'm Anjanette Levy. A courtroom security camera recorded Judge Tracy Soderstrom on the bench during a murder trial. The video, which was provided to the Oklahoman newspaper, shows Judge Soderstrom on her cell phone at different points during the trial. At one point, it appears to show text messages on the phone's screen. At another, a GIF is on the screen, and cameras also recorded her scrolling through Facebook. I contacted Judge Soderstrom's law office to let her know we wanted to ask her about this and invite her to talk about it on Sidebar. At the time of this taping, she hasn't responded to my request. The district attorney for Lincoln County, Adam Panter, told the Oklahoman courthouse staff tipped him off to the video showing the judge on her phone. He called it shocking and disappointing since jurors are banned from using cell phones in the courtroom because they are expected to give their full time and attention to evidence presented. Meanwhile, the attorney for the defendant in the case praised Judge Soderstrom, saying she did a great job. The jury found the defendant guilty of second-degree murder instead of the more serious charge of first-degree murder. Now, the Oklahoma Council on Judicial Complaints is investigating, according to the Oklahoman. So is the judge using the cell phone egregious misconduct, or is this a case of small-town politics at play? Joining me to discuss this controversy is Judge Susan Criss. She presided over Robert Durst's first murder trial in which he was acquitted of a murder, and she is now a former judge and an attorney. So, Judge Criss, welcome to Sidebar. Thanks for coming on.
Glad to be here.
So, Judge Criss, when you saw this footage, what came to mind for you? What was your take on it?
Well, on the one hand, technology is part of everybody's job and part of our lives. But at the same time, a judge has got to engage in listening to the trial and watching the trial and not missing anything. And when a judge appears to not be interested, that gives the jury and the public an impression. It may or may not be correct. Now, on the one hand, a judge might have seen the evidence and heard the testimony before many times in pretrial hearings, and it might not be the first time, but nevertheless, that's a huge problem. Is the trial is the priority.
As you mentioned, technology is a part of all of our lives. Cell phones are basically like a third hand or a third arm in some respects, and everybody has them with them. I mean, I have routinely seen in some high-profile cases that we've covered, judges with their phones out. I saw it in the Rittenhouse case. I saw attorneys in the Murdaugh case frequently on their phones, just looking like they were scrolling around during testimony and things like that. So I know it can be a distraction, but how do you think judges should handle cell phones on the bench, since this is an issue that has come up and we've seen in other cases?
Well, generally speaking, there's going to be some sort of computer on the desk, whether laptop or desktop, and you can't cut off communication. Like, you might be in a trial and your secretary might send you a message saying, "What time are y'all going to break for lunch?" Or "There's a witness that just showed up," or "Someone's sick and they can't appear," or "There's officers here waiting to do a search warrant in another case. What time are you going to take a break?" That's important. You can't cut that off. But you really don't need your phone for that. I mean, there's computers that you could do a lot more discreetly and just be on and off real quick, but the phone kind of just gives a different impression. And the phone could ring and someone could call you.
Yeah, we've seen that happen in the middle of a trial where a judge's phone rang. That happened in the Rittenhouse case. One thing that I found interesting about the reporting in the Oklahoman about this particular case is that sheriff's officials say that the Oklahoma Council on Judicial Complaints is investigating a complaint about this. The organization won't confirm that because their investigations or their complaints are not public. But obviously, there are people in that county that are upset about this, including the district attorney. Do you see a judicial complaint body such as the one in Oklahoma reprimanding this judge about this? Do you see any type of violation and, going on your phone and looking at Facebook and pulling up a GIF or a GIF, whatever they're called, during a trial?
Well, first of all, every state is a little bit different in what their ethical rules are. So I'm not 100% sure exactly what their rules are. They're probably pretty comparable to what we have in Texas. And one of the things in Texas is if someone files a complaint, our Constitution mandates that it be investigated by the commission. But that could go either way. But if the judge is giving the impression that the judge is not interested, then I could see it might not be a reprimand. It could be a warning. It could be a request for more education. There's a lot of different type sanctions but it's entirely possible.
What would a possible sanction for something like this be? I mean, what could that entail?
Well, in Texas, we have a public or private warning, a public or private reprimand, and there's another one. So, but it kind of depends on what happened and whether there's a history of this. But the problem that this judge has is this was such a public event that the public has an interest in it. If someone did something and didn't make the news, and it was something that could be remedied, and they thought, well, the judge understands and learned her lesson. But this isn't that. This is a very public thing. So the remedy would probably have to be public.
Interesting. It sounds like nobody would have known about this, which doesn't make it any better, but it sounds like nobody would have known about this had sheriff's deputies not tipped off the district attorney. The district attorney is very upset. This case was a first-degree homicide case, but the defendant was found guilty of second-degree murder. The defense attorney in the case says, "Oh, I thought the judge did a great job." District attorney, not so much. So could some of this, the complaint being filed and things like that, be kind of like a political issue? Maybe there's some tension there between the DA and this judge in particular?
There certainly could be. I mean, the winner isn't going to complain about anything regardless of how that goes. But here's the thing. I just have a hard time believing that it's something like this, it's the first time. I mean, we have our habits and we have our ways of dealing with things. And I can't believe that if this isn't something that wouldn't have happened before, that they wouldn't have picked up on it before. That's a hard part to believe. Now, another part of it is too, if you're on Facebook, if you're engaging, if you're just scrolling, then nobody out there in the world knows that you did it, except sometimes they can tell. Depends on what your privacy settings are. But if you're commenting or posting or doing things that show a significant amount of time involved and attention, then you've made a record of that. And so, of course, everybody can do this during their breaks or their lunch break or their coffee break and it not be that big of a deal. But if you have someone in trial all day and they're on Facebook all day and there's leaving a trail, a print, and that's a big problem. So I have a hard time believing that this just occurred out of the blue.
Interesting. Is this something that could lead to a defendant, say, getting a new trial? Obviously, the prosecution can't really go to an appeals court and demand a new trial over this, but a defendant could say, well, the judge wasn't paying attention, and I believe there were errors because of that.
That could certainly happen, and I think you could expect that, especially if they're. We make a lot of judgment calls on the bench. Some of them are about the quality of the evidence, or whether a predicate was laid, or whether there's a foundation, or whether an expert is really qualified. That you really have to listen, and if the judge is clearly not listening, then they're going to make some bad calls.
Sounds like Judge Criss is a big fan of no cell phone on the bench. And if it's on there, maybe put it in airplane mode or do not disturb. It sounds like that's probably what your advice would be.
It is. You have to be careful. You can't cut off all technology on the bench. And it helps. It helps to have some. But you have to do it in moderation. You have to be careful what impression you're leaving when you're on the bench.
Well, Judge Susan Criss, thank you so much for coming on to talk with us about this. We hope you'll come back. It's been great talking with you again.
You too, absolutely. Just let me know and I'll be back.
And that's it for this edition of Law and Crime Sidebar Podcast. You can listen to and download Sidebar on Apple, Spotify, Google, and wherever else you get your podcasts. And of course, you can always watch it on Law and Crime's YouTube channel. I'm Anjanette Levy, and we will see you next time.